You have probably heard the term living trust or revocable living trust. That is a type of an estate planning tool that is very common nationwide. And some states really, it's important in those states to have a living trust type setup. Other states, it's not so important. In fact, it can be a bad planning tool depending on what your goals are in other states, for example, Washington State. What is a revocable living trust? A revocable living trust is this entity that you create that is no different than you in many ways. It's not its own taxable entity. It's considered a see-through in that by tax, in that it doesn't even have its own tax ID number. It uses your Social Security number or your Social Security number and that of your spouse. Now, why would you create this revocable living trust? There's two primary purposes. The first is to administer assets during your lifetime, especially should you become incapacitated. Then you have this management system set in place via this living trust to manage your assets. Primarily, however, the purpose of a revocable living trust is to avoid probate upon your death or upon your spouse's death. A revocable living trust is set up so that on the death of the grantor, the trust owner, the assets go according to what the trust says. So if you are a couple, the trust likely will say on the death of the first spouse, their assets paid to an irrevocable trust that's within this revocable living trust, and the assets of the surviving spouse remain theirs in a survivor's trust. The whole idea is to avoid probate. If you are a single person, and especially, you may want to avoid probate and have your assets paid to whoever your beneficiaries are without the necessity of going through the probate process. So a revocable living trust can be an excellent planning tool depending upon what your assets are, what your goals are, and coming back to this, what state do you live in? If you live in a state such as California, commonly you will want to have a revocable living trust. State of Washington is a bit different, however. Our probate laws are very simple, so we're not so shy to use probate if there's a benefit to it. In Washington State, having a will, not a revocable living trust, having a will with a special kind of trust in it for your surviving spouse is one of our best planning tools to protect assets against long-term care costs for couples. In the state of Washington, therefore, we won't recommend a revocable living trust if you are married and your goal is to make sure that the surviving spouse of this couple never becomes impoverished due to long-term care costs. Because in the state of Washington, the only way to protect assets against Medicaid, against the state for long-term care costs, is if you use a will and a probate to create a trust after the death of the first spouse. A revocable living trust won't be honored. The state will count all the assets belonging to the surviving spouse, whereas if the couple used a will type of estate planning tool with the right kind of trust in it, the state will ignore all the assets that are in that trust for the surviving spouse. So what is the right planning tool for you? It really depends on what your situation is, what your goals are, what state do you live in. I'm at ELG Estate Planning, and we serve clients in Washington State and North Idaho. If you are in a different state, I recommend that you go to NALA.org to find an estate planning and elder law attorney in your state.